Hi, good evening to Professor Dr. Rozanah binti Abdul Rahman. So, my name is Muhammad Daniel bin Muhammad Faizal. My meeting number is EX03786. So, I'm going to present for subject Employment and Industrial Relation Law, which is the course code is MGM4331. Okay, so next. The topic that I choose for this presentation is sexual harassment. So we're going to talk about the Employment Act 1955 as at 30 April 2012 versus the Amendment 1, which is the Employment Amendment Act in 2022. Okay, so first of all, before we talk about this topic, what is sexual harassment to you? Some of us, we heard about sexual harassment cases, sexual harassment at the workplace and so on, but we doesn't know what is sexual harassment is. So without wasting our time, I'm going to show you a short video about sexual harassment at the workplace. So at least you have the picture what is sexual harassment is.
क्या बकवास है ये क्या चिल्लाते रहते हैं एम्पावरमेंट एम्पावरमेंट सब नखरे हैं काम ना करने के बहाने हैं ये सब
That moment where we feel undignified, eyes scanning our curves, sensing the hand slide. When men boast about their masculinity with utmost pride, we appear perfectly calm outside, yet broken inside. It lies in the promise of rewards in lieu of sexual favors, as if we aren't human beings but some lollipop flavors. What might appear to you as just a remark, make no mistake, can leave a scar. When rumors and jokes become so intolerant and outrageously bizarre, when we try to raise a voice against your advancements, you blame us for smiling and indecency, trying to justify sexual harassment. We plead, we bear, we feel, we fear, we love, we hate, we create, we tolerate. Till how many times should we ignore and forgive in the name of mere mistake? How long can we bear? At what point should we say, we can't take it any longer? We can't take it any longer.
Okay, so from here we receive a short video about sexual harassment at workplace. So I hope that all of you can understand what is sexual harassment at the workplace. Okay, so this is the cases in Malaysia. I've screenshot one of the article in HRM Asia, which is the sexual harassment report search in Malaysia. So as you can see that have been highlighted here, according to the police statistic, there were 477 documented cases of sexual harassment in 2022, representing a decrease from the 506 cases reported in 2021, and most victims were women. So basically in that, I can see it's actually good statistic, which is decreasing compared to 2021. But still, even though it's decreasing, it still have a amount that 477, which is for me a big amount, that we need to take this very serious. So in this case, that's why most of the employee must understand the law for the sexual harassment, so that if they have been one of the victims of sexual harassment, they know what to do and what action should be taken to that person. Okay, I'm going to show you another short video about the sexual harassment workplace cases in Malaysia.
Have you ever wondered why some workplaces seem to foster a culture of silence around sexual harassment? Today, our focus shifts to the Southeast Asian nation of Malaysia, where we delve into specific instances of workplace sexual harassment. Consider the case of Malaysia's Health Ministry, which came under fire in 2021 for publishing an article that attributed sexual harassment to women's physical appearance. This narrative not only perpetuated victim blaming, but also reflected a larger pattern of sexist remarks by Malaysian politicians. The Health Ministry's Director General acknowledged the negative perception created by the article, leading to its deletion. However, the damage was already done, and the incident served as a stark reminder of the sexist attitudes that often underpin workplace sexual harassment. Moving on, let's explore the legislative landscape of sexual harassment in Malaysia. In 2022, the Anti-Sexual Harassment Bill in Malaysia aimed to broaden legal options for survivors by creating a special tribunal. Although this bill addressed sexual harassment in various settings beyond the workplace, it was met with criticism. Activists argued that it fell short, citing concerns about the lack of legal representation for parties involved and the potential for the tribunal system to fail survivors, just as the existing system has. In some instances, women have turned to social media and the press to seek justice when official channels have proven ineffective. This reliance on public platforms for redress highlights the systemic issues in addressing workplace sexual harassment in Malaysia. What can we do to support initiatives against workplace sexual harassment? First, we can educate ourselves and others about the reality of sexual harassment and the impact it has on victims. Second, we can advocate for stronger laws and policies that protect victims and hold harassers accountable. Third, we can support organizations that provide resources and assistance to those affected by workplace sexual harassment. Remember, change begins with awareness. Let's strive to create work environments where everyone feels safe, respected, and valued.
Okay, so next, we're going to talk about the Employment Act 1955 as at 30 April 2007, which is the Act 265. Okay, so the first act for the sexual harassment is 81A, which is the interpretation. So as we can see here, complaint relating to sexual harassment made is by an employee against another employee, which is one employee to another employee, maybe their partner and or their friends or their working colleagues and so on. Second is by an employee against any employer, means that the employee itself against their maybe their supervisor or their manager or someone has upper level compared to them. And the third one is by an employer against an employee, which is the manager itself made a complaint towards their staff, which is their employee, which is for me is a rare case, but it still happens there. Okay, so that is the 81A. So next one, we're going to talk about 81B, which is inquiry into complaints of sexual harassment. Okay, the first one, once the employer gets the complaint, they shall inquire into the complaint in manner prescribed by the minister. Once they get the complaint about the sexual harassment cases, they must go and investigate that cases, but in a manner of prescribed by the minister. They must follow the rules and regulations that have been set up by the minister itself. Second, if the employer refuses to investigate the case as in number one, they should provide the reason for refusal as in written. Means that if the employer itself refuse, that they said they don't want to investigate these cases, they must give reasons towards the complainants why they don't want to investigate these cases, and the reason must be in written. Number three, the employer can refuse to investigate if two cases. First one is previously been inquired into and no sexual harassment has been proven, means that these cases have been reported before this, but the last time is there is proven there's no sexual harassment happened for that. And the second one is the opinion that the complainant of sexual harassment is frivolous, vexatious, or is not made in good faith. Means that maybe the employer thinks that the complainant made this complaint with not a good face, which means they try to sabotage their friends and so on. So that one they can refuse to investigate. Next is 81C. So 81C is the interpretation. If the employer has proven that there is a sexual harassment after conduct 81B just now, they shall first take disciplinary action, which may include the following. Got three types, which is dismissing the employee without notice. They can just dismiss the employee without any notice. Second one, downgrading the employees, which is if they have their rank in that company, they can downgrade the rank as a punishment. And the third one, imposing any other lesser punishment as he deems just and fit, and where the punishment or suspension without wages is imposed, it shall not exceed a period of 2 weeks. Means that maybe they can suspend the employee for 2 weeks without any wages and so on, but cannot exceed more than 2 weeks. Or maybe they can give another punishment that they think it suits towards that issue. And the next one is in the case where the person against whom the complaint of sexual harassment is made is a person other than an employee, recommend that the person be brought before an appropriate disciplinary authority to which the person is subject to. Means that in this case, to make that words very simple, they will bring this person towards someone that can have someone that have the authority about the disciplinary action, and that person will judge what kind of disciplinary action should be taken towards that person. Next is 81D, complaint of sexual harassment made to the Director General, which is the DG. Okay, so has 6 rules here. There you go. Number 1, Director General shall assess the complaint and may direct an employer to inquire into such complaint. Means that once the Director General, which is the DG, get the complaint about the sexual harassment, they must ask the employer to make the investigation towards the case. They have the power to directly ask the employer to investigate the cases. Second one, the employer shall inquiry into the complaint of sexual harassment when directed to do so and submit a report of the inquiry to the DG within 30 days from the date of such direction. Means that once the employer get the what we call that arahan from the DG, so they should make the investigation on the spot and they need to give back the report towards the DG within 30 days. They cannot exceed 30 days. That's the rules there. The third one is DG shall inquire into such complaint himself if complainant of sexual harassment receipt is made against an employer who is a sole proprietor. So, in this case, if let's say the DG get the complaint and the complaint is from the manager itself, which is from the employer itself, so they cannot ask the employer to investigate themselves. So what should DG do? DG will go and do the investigation by himself for that cases. Number 4, DG have to decide if sexual harassment is proven or not. Whatever it is, they have to decide. Is it proven or not? They cannot make that complaint is hanging or floating. Number 5, DG may refuse to inquire into any complaint if 2 cases, complaint of sexual harassment have previously been inquired and is proven not to be, same as just now one in it. The second one is the opinion that the complainant is not made in good faith. So they can refuse to investigate this complaint if last time they have the same complaint and it's proven not to be. And the second one is they think that this complaint is not in a good faith. And number six, they must inform the complainant within 30 days of the refusal and the reason for the refusal in writing. If they refuse to investigate the cases, they need to tell the complainant within the 30 days why they don't want to investigate the cases, and that refusal must be in written. Okay, next is 81E, effect of decision of the Director General. So, if sexual harassment is proven undergo 81D4, the complainant may terminate his contract of service without notice. If, let's say, it's proven that there is a sexual harassment, the complainant is right, so the complainant can simply terminate their contract of service without any notice. Means that maybe for them, they cannot continue to work there because sexual harassment is a very big cases, so they can just terminate their contract without notice. If not, if follow the normal rules, we need to give a notice at least 1 month, 2 months, or 3 months. But in this case, without notice. Number two, if the complainant terminates the contract of service under subsection 1, which is just now one, the complainant is entitled to two cases, get the wages as if the complainant has given the notice of the termination of contract of service. Means that they will get the wages like they have given notice. They give a notice to terminate their contract. And the second one is termination benefit and indemnity as provided for under the act or the contract of service. What kind of the benefit that they should get if they make it a proper termination notice. So in this case, that person also will get exactly the same based on the company rules and regulation that have been stated there. And next is 81F, which is the offense. If employee fails to, got three cases here. If the employee fails to inquiry into complaint of sexual harassment under subsection 81B1. Second is to inform the complainant of refusal and the reason for the refusal as required under subsection 81B2. To inquire into complaint of sexual harassment when directed to do so by the DG under paragraph 81B5A or subsection 81D2. To submit a report of inquiry into sexual harassment to the DG under subsection 81D, they will commit an offence and shall or conviction be liable to fine not exceeding 10,000 ringgit. If they fail to do these four things, they will be fined not more than 10,000 ringgit. That is the rules. Okay, so last one for Employment Act 1955 as at 30 April 2012. Application of this part irrespective of wages employee. 81G. Notwithstanding paragraph 1 of the first schedule, this part extends to every employee employed under a contract of service irrespective of the wages of the employee. Means that this act is can be used by all of the employee that is under contract of service. Doesn't care what kind of wages they are getting every day and month. Okay, so next I'm going to talk about the Employment Amendment Act in 2022, which is the Act A1651. So just now in 2012 is the main act that have been made for the sexual harassment. So what's the difference in 2022? What have the government changed? So we will have a look. Not that much actually. So the first one is the amendment section of 81F. You have heard just now, section 81F of the Principal Act is amendment by substituting for the word 10,000 ringgit to the word 50,000 ringgit. Means if the employer fail to do that 4 things that I said just now, they will be fined not more than 50,000 ringgit, not 10,000 ringgit anymore. Which is for me is fair because if in 2022 10,000 ringgit is nothing for a big company, so 50,000 ringgit is much better to find that company if they fail to do so. Next one is Deleting of Section 81G, the principal act is amended by deleting Section 81G. So the last act in the Employment Act 2012, they have deleted this section, the 81G. And the last one is they have made a new section which is 81H. The principal act is amended by inserting after section 81G the following section: notice of sexual harassment, 81H. An employer shall at all times exhibit conspicuously at the place of employment a notice to raise awareness of on sexual harassment. Means that the employer itself and all the employees must always have notice to raise the awareness on sexual harassment. They must have a very clear notice at their office or maybe at their social media, at their WhatsApp group and so on about the sexual harassment notice. So they need to remind if anything happen, what they need to do. So at least we can decrease the amount of sexual harassment cases. If there is no awareness, people not try to do their best to avoid this thing, this case will keep increasing. Even though in 2021, in 2022 it decreased from 2021, but if there is no awareness, it's possible to increase back. So if we keep putting awareness towards people, maybe in 5 years we can have the minimum amount of sexual harassment in Malaysia. So this is good for me. Section 81H, the new section, is good. So that's all for me. I hope that at least you know what to do if you are one of the victim for the workplace sexual harassment. We have law, we have rules, we know what to do. Don't let sexual harassment cases keep increasing in Malaysia. So say no to workplace sexual harassment. I think that's all from me. Thank you very much.